Hi guys, welcome back to the channel. Let's try to understand the relationship between a driving under the influence and a procedural fairness letter and a potential inadmissibility, because all these things are sort of related to one another. So let's try to understand as much as practically possible. I'm Niladri Mukherjee. I'm a regulated Canadian immigration consultant, and as an organization, we predominantly focus on addressing issues concerning procedural fairness letters, criminal inadmissibilities, TRPs, and stuff like that. Okay. So driving under the influence is something like you have driven while consuming alcohol, right? Simple as that. As long as you are not caught, it's fine. But if you are caught and if you have received a conviction or a sentencing, it's a problem here in Canada. I would say it's a serious problem here in Canada because the driving under the influence is being considered under serious criminality. Okay, so I'm not going into the differences between the criminality and the serious criminality and all those sort of stuff, because those things could potentially make it a complicated one. A simpler thing to understand: criminality has got a lower threshold, serious criminality, as the name suggests, has got a upper threshold, and therefore makes it even more difficult for you to potentially come to Canada even on a temporary basis. Okay, so if you have a driving under the influence record in your driving under the influence in your record, okay, from whichever country it is, most importantly from one of the information sharing countries, let's say Australia, New Zealand, US, UK, and all those countries, Canada will be able to see that while they are assessing your application. Okay, so ideally, one could do is that one could apply for a criminal rehabilitation if the 5 year has passed, get a criminally rehabilitated, and then apply for a visa. You should all be fine if your criminal rehabilitation application is approved. And obviously, there is no guarantee that it will be approved even after 5 years. It's not an automatic guaranteed process, but you have to prove that you are indeed a rehabilitated person. As a part of that process, you may go for an interview and stuff like that. Again, that's a different story altogether. Okay, but let's say the 5 year has not yet passed, yet you have a mandatory requirement or a super urgent requirement for you to come to Canada. Then what you do? Okay, in this case, on an apparent basis, it is easier for you to, I would say, it is important for you to make an assessment that that urgent reason that you're talking about, whether that would be considered as urgent from IRCC's perspective. Okay, now let's say, for example, if you are an American citizen, or let's say if you're an Australian citizen, and if you want to come to Canada to attend a wedding, or maybe you are a player, you want to play basketball or a hockey, for example, and you are not criminally rehabilitated, you can then potentially apply for something called a temporary resident permit and can come to Canada temporarily while you are still being otherwise considered as criminally inadmissible. Okay, so if you have received a temporary resident permit, that does not mean that that will automatically have made you criminally rehabilitated. That just means that even though while you were still inadmissible, Government of Canada is giving you an option to come to Canada on a temporary basis. Okay, that's for those like visa exempted or ETA required countries. But let's say if you're an Indian citizen, okay, and you want to come to Canada on a study permit with a TRP, practically it will be very difficult for you to get a TRP citing that kind of a nature, even though you say that, let's say I got a letter of acceptance from McGill University, I have a fully paid scholarship, or I have gotten into a PhD and stuff like that. Even then, the possibility of success for you will not be very high for a TRP, because the threshold is way too high for you to prove that you will indeed leave Canada well within the time maximum, well within the maximum time allowed for your temporary stay. So there are options available on the table, depends on the case. I have handled applications, particularly for spousal sponsorship applications, okay, where the person got a DUI while the spousal sponsorship application was in process. So the sponsor obviously did not declare that, received a procedural fairness letter, and the IRCC had decided to approve those applications under humanitarian compassion grounds, where the sponsor was a Canadian citizen, or when the sponsor was even a permanent resident of Canada. Okay, so the person was not even been criminally rehabilitated, yet humanitarian grounds applied on those cases. I have had examples of temporary resident permits where the spouse here living here in Canada as a citizen, the wife is inadmissible, and then she was able to visit the husband on a TRP, on a temporary basis, and she was from one of the visa exempt countries. Okay, so there are options available. So if you have any kind of driving under the influence on your record, it's definitely a good idea before you submit an application, take a professional consultation to understand the options. Because if you just decide to, if you think that, well, I have paid the fine, I have served the sentence, means it is done and dusted, it may not be done and dusted here in Canada. It may then take a very long time for you to get a decision. I have seen cases where people did not declare their DUI properly, like the way it should be. They're not criminally rehabilitated, they have submitted the study permit applications or even visitor visa applications. Those applications are there in the system for over 16, 17, 18 months, where the otherwise processing time is less than 1 month. Okay, you may send as many web forms as possible. You may raise as many GCMS notes requests as practically possible. Nothing really happens when these applications are being sidetracked. So for your best interest, it's a good idea to understand the options available on the table and make an application only when it makes sense for you to make an application. Okay, it's not about $100, $200 here and there. It's about being in the limbo which you do not want. If you need our professional assistance, more than welcome to hop into our website nuvonation.ca, book a relevant professional consultation. I'll be very happy to have a case specific discussion with you. Hope this helps. Bye.